Dear ladies and gentlemen, let me welcome you at the afternoon panel of this year's Legalsummit conference. Following the morning discussions focused much more on the aspects of the justice reforms and on the topics of the content of the law. Now in this panel we would like to focus a little more on the technology and more be the innovation aspect. Maybe this is not one of the most typical aspects of the legal practice, but I'm sure the distinguished speakers I would like to welcome are ready to show you how the technology will become much more important part of the legal practice. So please let me introduce the board of the panelists. First, as an online speaker, let me introduce Mrs. Lucia Ďuriš Nicholsonová, the member of European Parliament. Then Mr. Milan Andrejkovič, who is a main data curator of the Slovak Republic at the Ministry of Investment, Regional Development and Informatization of the Slovak Republic. Welcome. We will also hear the keynote as a case study from Mr. Jakub Zeman, who is an analyst at the Supreme Audit Office of the Slovak Republic. Welcome. Then Mr. Massimo Dona, who is the director at the technology group of Paradigma Law and Strategy, who is also online. Welcome.
Thank you. Good afternoon.
Mr. Anton Artim is head of the IT Solutions Department at the company L.Com. So welcome at our discussion.
Good afternoon.
Mr. Martin Krendl, who is an attorney of law at Prosman Pavlović, who is the distinguished exclusive partner of this conference. So welcome at the discussion. Mr. Marian Čuprík, who is member of the Attorney Service Electronization Work Group at the Slovak Bar Association. Welcome to the discussion. And Mr. Marek Kryška, who is co-founder of the company Sparing, who is really mixing the world of technology and law. Welcome.
Thank you for having me.
So for the opening, let us see the situation of pandemic has maybe practically shown that the innovation and the technology employment in the legal practice is not something of a buzzword or something only popular, but really kind of an important part of practice. And before we start the discussion, let me ask Mr. Jakub Zeman, who is the analyst at the Supreme Audit Office of the Slovak Republic, to show us a case study in this field from his practice as a keynote. As first, Mr. Zeman will speak in Slovak, and afterwards I will present the short English summary.
Dobrý deň, tak volám sa Jakub Zeman, som analytik Najvyššieho kontrolného úradu Slovenskej republiky a v krátkosti by som vám povedal náš pohľad vlastne ako inovácie podporujú právny štát. Moja prezentácia bude mať také 3 časti. Prvé vám poviem vlastne v krátkosti, čo robí náš Najvyšší kontrolný úrad, akú má pôsobnosť. Potom, prečo sa zaoberáme právnym štátom, taktiež v rámci našej kontrolnej činnosti a súčasne vám poviem vlastne naše kontrolné a analytické zistenia. Môžete ísť na ďalší slajd. Dobre, tak náš vlastne Najvyšší kontrolný úrad je nezávislá štátna inštitúcia, ktorej pôsobnosť je vymedzená Ústavou Slovenskej republiky a taktiež samostatným zákonom. Treba ale povedať, že najvyššia kontrolná inštitúcia v demokratickej spoločnosti je však parlament. Aby ste tak vnímali, že koľko má cca zamestnancov, je to 300 zamestnancov, pričom vlastne výkonných kontrolórov, auditorov je približne 230 a ostatní zamestnanci sú v podporných útvaroch. Kontrola sa môže zameriavať na subjekty, ktoré nakladajú so štátnymi, verejnými či európskymi zdrojmi a tak Najvyšší kontrolný úrad Slovenskej republiky môže kontrolovať viac ako 17 000 subjektov. Či už je to štátna správa, verejné korporácie, samosprávne inštitúcie, právnické či fyzické osoby využívajúce verejné či európske zdroje. Môžete ísť na ďalší slajd. Vzhľadom na ten počet tých možných kontrolovaných subjektov a obmedzenosť aj tých personálnych zdrojov, tak tá kontrolná činnosť musí byť cieľavedomá a projektovaná činnosť. Najvyšší kontrolný úrad nemá žiadnu zásahovú jednotku, ktorá po zistení nejakej kauzy vôjde do nejakej inštitúcie, ale všetká naša činnosť je cieľavedomá a projektovaná. Napríklad V roku 2020 Najvyšší kontrolný úrad realizuje 32 kontrolných akcií v približne 220 kontrolovaných subjektov na základe ročného plánu. Okrem toho, že vlastne úrad sám si vytvára nejakú tú projektovanú činnosť, taktiež aj Národná rada Slovenskej republiky môže uznesením uložiť úradu povinnosť vykonať kontrolnú akciu a súčasne úrad môže reflektovať podnety, ktoré dostávajú od verejnosti. Napríklad v predchádzajúcom období bolo približne 600 podnetov od verejnosti a napríklad v roku 2020 boli na základe rizikovej analýzy zaradené do kontroly 2 podania. Tu treba ale povedať, že tých 600 podnetoch ročne sú rôzne podania a konkrétne keď hovorím o tej justícii alebo právnom štáte, tak často sa nás obracajú obvinení či odsúdení, ktorí chcú, aby sme sa pozreli na to, či ich trest alebo vzatie do väzby je zákonné. To však úrad nemôže kontrolovať, respektíve nemá na to kontrolnú právomoc, keďže vlastne kontroluje práve len tie verejné zdroje. Môžeme na ďalší slajd. Vzhľadom na to, ako som povedal, že tie zdroje sú obmedzené a tá činnosť je plánovaná, tak Najvyšší kontrolný úrad má vytvorený dokument Strategické oblasti zamerania kontrolnej činnosti Najvyššieho kontrolného úradu Slovenskej republiky na roky 2021 až 2023. V tom je jedna z 8 verejných politík práve právny štát a bezpečnosť. Tento strategický dokument nebol realizovaný len vlastne úradom, ale taktiež v spolupráci s externými partnermi, ktorí práve poukázali na to, že téma právneho štátu a bezpečnosti je pre nich najprioritnejšia. Taktiež aj pre nás je to dôležitá oblasť, keďže podiel výdavkov na HDP do oblasti právneho štátu a bezpečnosti je v priemere 3,1% za rok. Z toho dôvodu do prioritných oblastí zamerania kontrolnej činnosti v roku 2021 sa dostala práve informatizácia v súdnictve a v najbližšom období by mala realizovať sa aj kontrola. Môžeme ísť na ďalší slajd. Vzhľadom na túto významnú tému Najvyšší kontrolný úrad Slovenskej republiky realizoval analytickú štúdiu, ktorá sa práve venovala slabej elektronickej komunikácii a meškajúcemu obchodnému registru. Vlastne pozreli sme sa na celý ten stav a elektronizáciu súdnictva. Môžeme ďalší slajd. Predtým, ako sme sa pozreli ale na to, ako funguje naše súdnictvo na Slovensku, respektíve aké sú jeho úskalia, sme sa pozreli na to, že prečo je táto téma dôležitá. Konzultačná správa Medzinárodného menového fondu hovorí, že zvyšovanie dôvery v justíciu môže pomôcť pri zlepšovaní všeobecného podnikateľského prostredia a tiež pri zachovaní stability v oblasti konkurencieschopnosti podnikov. Taktiež aj Európska komisia hovorí, že ak súdne systémy zaručujú vymáhanie práv, veritelia s väčšou pravdepodobnosťou požičiavajú, podniky sú odrádzané od oportunistického správania, transakčné náklady sú znížené a taktiež inovatívne podniky častejšie investujú. OECD poukazuje na to, že medzi faktormi, ktoré sa spájajú s kratšou dĺžkou súdneho konania, patrí vyšší podiel výdavkov na automatizáciu v súdnictve, aktívny manažment prípadov či systematická tvorba štatistík. Na základe týchto medzinárodných zistení a poukázaní sme taktiež vlastne zamerali náš komentár hlavne na tú informatizáciu, a to najmä v podnikateľskom prostredí. Tieto oblasti, ktoré ďalej budem vymenovať, neboli vybrané náhodne, ale taktiež sme oslovili práve subjekty, ktoré používajú tie informačné systémy v súdnictve, a to súdkyňu, taktiež vyššiu súdnu úradničku a jednu z najväčších advokátskych kancelárií na Slovensku. Poprosím ďalší slajd. Takže hlavne také zistenia z toho analytického komentára sú následovné. Ministerstvo spravodlivosti síce realizovalo v predchádzajúcom období reformy, ktoré sa týkali podnikateľov, ktoré napríklad zaviedlo elektronické doručovanie, elektronický súdny spis či register doložiek. Avšak tá kvalita týchto reformy je pre štát a užívateľov z dôvodu ich neúplnosti, nedostupnosti či kvality elektronických služieb nedostatočná. Ak sa pozrieme na tú neúplnosť, tak príklad je napríklad register doložiek právoplatnosti. Ten by mohol, aj Ministerstvo spravodlivosti hovorí, že v nejakom časovom úseku aj bude právne záväzný, ale v súčasnosti má len informatívny charakter. Čiže vlastne ten cieľ, ktorý mohol dosiahnuť to Ministerstvo spravodlivosti, nebol dosiahnutý v súčasnosti, lebo ten register doložiek má v súčasnosti informatívny charakter a tá hodnota za peniaze mohla byť v tom čase vyššia. Taktiež nedostupnosť je napríklad v prípade elektronického doručovania, keď Ministerstvo spravodlivosti nás informovalo, že má týždenné odstávky tohto systému po 16. hodine v priemere okolo 1,5 hodiny. Keď sa pozrieme na iné informačné systémy, tak oni nepotrebujú takéto časté odstávky, prípadne sú tieto odstávky realizované cez víkend, prípadne po polnoci. Keď vieme, že akí sú užívateľia práve informačných systémov v súdnictve, sú to často advokáti, ktorí do poslednej chvíle chcú využiť tú svoju lehotu a po tej 16. hodine to je ešte možná ten čas, kedy oni pracujú. Ak sa pozrieme na kvalitu elektronických služieb, tak tam sme vlastne s tou advokátskou kancelárou našli veľa oblastí, kde by sa dalo zlepšiť, napríklad užívateľská vhodnosť toho elektronického doručovania, či taktiež ten súdny spis by sa dali zlepšiť. A druhým takým hlavným zistením z toho analytického komentára je to, že na elektronické služby vplyva aj to, že Ministerstvo spravodlivosti aktuálne nasadené služby nevyhodnotilo s odstupom času z pohľadu užívateľskej vhodnosti. To je, nerealizoval žiadny dotazník alebo prieskum o tom, ako sú tí užívateľia spokojní s tými informačnými systémami a či im vyhovujú pri práci, prípadne nerealizoval nejaké zlepšenia. V súčasnosti Ministerstvo spravodlivosti realizuje aj viacero nových projektov v rámci informatizácie justície a v súčasnosti mu absentujú personálne kapacity na to. Môžeme ďalej. Ďalším takým zistením je to, ako som povedal pri tých medzinárodných zisteniach, tak tá dôvera v justíciu je veľmi dôležitým determinantom kvality podnikateľského prostredia. Na tomto grafe môžete vidieť, že tá dôvera, respektíve nedôvera na Slovensku prevládajúca a vlastne patrí medzi najhoršie v rámci Európskej únie. Taktiež, ak sa pozrieme na tú dôveru v nezávislosť súdnictva, tak v Európe cca polovica osôb dôveruje v súdnictvu. Ak sa pozrieme ale na Slovensko, tak na Slovensku je len to cca 15% podnikateľov a necelých 26% občanov. Môžeme ísť ďalej. Ako som povedal, aj náš komentár bol zameraný aj na obchodný register, keďže je to dôležitý informačný systém pre podnikateľské subjekty. V tom čase nasadenia, ako ho v súčasnosti ešte poznáme, tak to bolo na začiatku 21. storočia, v roku 2001-2002, a tak v tom čase predbehol dobu. Veľa krajín sa inšpirovalo, ale v súčasnosti po skoro 20 rokoch je užívateľsky nevhodný pre súdy a súčasne aj pre verejnosť. Taktiež v tom obchodnom registru sú aj firmy, ktoré by súdy mohli ex ofo vymazať, mohli a mali ex ofo vymazať, avšak vzhľadom na preťaženosť obchodných registrov, tak takúto činnosť nevykonávajú. Nový obchodný register v súčasnosti sa plánuje, avšak mešká vzhľadom na predĺžujúce sa verejné obstarávanie a súčasne nedržanie plánovaných lehôt, ktoré si ministerstvo vytýčilo. Môžeme ísť ďalej. S tým obchodným registrom sa aj spája taká činnosť, ktorú mali súdy vykonať do konca roka 2020, respektíve podnikatelia mali vykonať do konca roku 2019 a súdy mali zapísať konečných užívateľov výhod do konca júna 2020, avšak to nezvládli. Hej. Ten zápis konečných užívateľov výhod sa týkal všetkých obchodných spoločností na Slovensku a nadmerne preťažil súdy. Vlastne Ministerstvo spravodlivosti nezabezpečilo žiadny nejaký špeciálny informačný systém, ktorý by pomohol sprocesovať registráciu konečných užívateľov a aktuálny ten systém obchodného registra nebol vhodný ani dostatočný na povinnosť, s ktorou sa súdy museli vlastne vysporiadať. Zápis konečných užívateľov výhod nadmerne zaťažil súdy pri vyvádaní agendy obchodného registra. Čiže vlastne automaticky nastalo predĺžovanie lehôt, kedy vlastne registrové súdy majú zapísať obchodné spoločnosti do obchodného registra, čo podľa zákona majú 2 pracovné dni byť. A vzhľadom na to, že preťažujú sa tie súdy, neboli nejaké lepšie informačné systémy v tom súdnictve, tak sa to nestalo. Podľa nášho názoru vlastne nebol zvládnutý aj tento zápis konečných užívateľov výhod a je to ďalším príkladom vlastne zlej praxe v informatizácii spoločnosti. Môžeme ísť ďalej? Toto sa nejak posunulo, ale vlastne keď sa pozrieme na tú technologickú infraštruktúru v súdnictve, tak Najvyšší kontrolný úrad Slovenskej republiky realizoval v roku 2017 kontrol, kedy sa zameral na alternatívne tresty, to je elektronické náramky. Možno ste o tom už počuli v médiách. A vlastne vtedy Najvyšší kontrolný úrad konštatoval, že sa nepodarilo dosiahnuť deklarované prínosy zo zavedenia systému, ktorí mali prispieť úsperu nákladov na väzenstvo. Elektronické náramky len minimálne vlastne podporujú ukladanie alternatívnych trestov a ich počet zostáva v porovnaní s obdobím pred realizáciou projektu takmer nezmenený. Ak sa pozrieme na tú nákladovú časť, tak zatiaľ čo štát zaplatí na pobyt jedného väzňa vo väzení približne 40 eur, náramok stojí približne 4 eurá na deň. Cieľom bolo, aby tento systém používal približne 2000 osôb ročne, avšak v čase kontroly to boli desiatky osôb, v súčasnosti sú stovky, čo som pozeral, ale stále ten cieľ nie je dosiahnutý. Môžem ísť na posledný slajd? A prepáčte, ešte big data alebo dátovej analytike v rámci súdnictva, tak Najvyšší kontrolný úrad Slovenskej republiky jednoznačne vidí zlepšenie kvality, dostupnosti a pravidelnosti zverejňovania údajov zo strany Ministerstva spravodlivosti. Konkrétne analytická jednotka, ktorá tam funguje, tak má správené webové sídlo, kde pravidelne zverejňujú informácie o dĺžke konania či nápadov na jednotlivých súdoch a užívateľ vie prakticky zistiť na každom súde, ako funguje, koľko má personálnych kapacít rozpočtu a podobne. Súčasne vidíme príležitosť pre Ministerstvo spravodlivosti v projekte váženia prípadov, ktorý vlastne môže zlepšiť manažment v súdnictve. Tento projekt váženia prípadov by znamenal, že by sa zaviedli časové limity a rámce na jednotlivé časti súdneho konania. Avšak tento projekt váženia prípadov ešte nebol realizovaný vzhľadom na koronakrízu. A v súčasnosti sa presúva na rok 2021, ak si dobre pamätám. Môžeme ísť na ďalší taký záver. Takže Najvyšší kontrolný úrad konštatuje, že vlastne všetky činnosti, ktoré vedú k zvýšeniu efektívnosti, hospodárnosti a účelnosti vynakladania verejných zdrojov, sú zo strany Najvyššieho kontrolného úradu Slovenskej republiky vítané. Či už sa pozrieme na tú umelú inteligenciu, ktorá môže zlepšiť vynakladanie verejných zdrojov, alebo big data a podobné iné technologické možnosti. Možno posledný slajd. Ja vám ďakujem za pozornosť. V prípade, ak by ste mali nejaké otázky, môžete sa obrátiť na nás a môžete sledovať našu kontrolnú činnosť. Ďakujem.
Thank you very much, Mr. Zeman. Just to very briefly summarize your presentation for Mr. Dona and the English-speaking part of auditorium. The Supreme Audit Office of the Slovak Republic is a national authority providing inspections of the external state controls to all the entities that manage state, public or EU resources. Among the major or most important priority areas of the Slovak Republic, including which are also the priorities of the Supreme Audit Office of the Slovak Republic, there is also one of the area of rule of law, democracy and security. Following this priority area, the SAO welcomes the electronic administration of the judiciary, which has a significant impact on shortening the proceedings and can make a positive contribution to increase the credibility and of the judiciary in the eyes of the public, but also welcomes it as a way to really optimize the management of the public sources. The major areas of the SAO's comment are focused on the electronic communication between the court, which lags far behind, especially in the areas of the helping entrepreneurs. Now the Ministry of Justice is facing some key changes in the business register digitalization and simplifying the processes of registering the companies. The SAO and its auditors positively rate the introduction of some electronic services for entrepreneurs, including electronic delivery, electronic court filing or registering of cases. However, they still point out that there are the systems are still not in a user-friendly position and just partly implemented the debureaucratization of the courts and fulfilled the anti-bureaucratic principle once and forever. So then, for example, the process of registering the end beneficiaries has not only been mastered, and it is another example of the maybe not the best practice in the informatization of the society. Among the other key findings of the analytical commentary, although the Ministry of Justice implementing reforms in the previous period, some of the electronic services are a little late in the implementation, including the electronic delivery, cold files, or some registries. and the auditors state the incompleteness and availability of some quality issues in the electronic services. Part of the services are affected by the fact that the Ministry of Justice did not evaluate the currently deployed services over time from the point of view of the user suitability. In addition, it lacks the personal capacity and implement the currently planned projects. The information system that would help process of registration to the final beneficiaries and using the current system of the commercial register is not still suitable and is waiting for the major upgrade, and thereby there are also still some infrastructure issues. Among some other interesting projects, the electronic bracelets are the example of the project for the alternative punishments, but still are just used in quite a minimum way. One of the biggest issues, but still with a positive impact, there are the application of the big data technology, and one of the biggest issues are among the automatization and virtual space and blockchain and other technologies using in the judiciary practice. Well, this is just a brief summary, but maybe to show more, let me open the discussion and just let the distinguished speakers to introduce themselves and really their relationships to the topic. First, let me start with Mrs. Ďuriš Nicholsonová. Well, we see European Union is not only a ruling translator or a requiring authority, but also with its states kind of a source of inspiration. So what are maybe now the main initiatives of the EU in employing technology in law?
You were talking about the virtual courts related to the pandemic. I have to say that, yes, I mean, we are witnessing that basically the pandemic made all the changes that leads to digitalization, automation, much faster than we expected ever. And of course, we can see the potential of virtual hearings because they have risen during the COVID-19 pandemic with the limitation of the number of people to be present in courtrooms, etc. And we even have countries within European Union who came up with temporary legislation and started to more widely use such legislation already in place, which follows the remote court hearings. For instance, in Spain, Austria, Germany, Italy, and the UK as the previous member of European Union. Now, while the virtual hearings work better in some legal contexts than in others, and particular care must be taken not to lower the standards in criminal cases where changes might affect the human rights of defendants. But, however, today the reality is that more people in the world actually have access to the internet than to justice. According to OECD, only 46% of people live under the protection of the law, whereas 50% of people can actually access today internet in any way. There are quite a few disadvantages of this remote or online court hearings, insufficient professional technical equipment in courtrooms. Now we have really huge gaps in the whole digitalization of justice systems in the EU. I will come back to that. There is a loss of non-verbal communication that might inhibit the ability of advocates to know when defendants want to speak. It could make defense advocates less effective, and we also have to take in account the witness testimony challenges that we, of course, are facing when talking about using the IT when it comes to the courts. The court might consciously take into account the shortcomings of virtual hearings when evaluating witness or experts' testimony. Witness unfamiliar with online meeting platforms might not convincingly look directly at the questioner, raising concerns at their credibility and etc. So we are facing really huge challenges and a lot of open questions when it comes to the artificial intelligence in judicial system. There is really, as I mentioned, a huge gap between the member states, a huge digitalization gap between the member states. Just recently, the Commission revealed a mapping of digitalization of justice in member states, and I have a few numbers here. The individual can access an electronic file of their ongoing cases only in 10 member states in all types of civil law procedure. In the context of criminal law, victims can access an electronic file only in 7 member states of all types of criminal proceedings. Evidence can be submitted to a court exclusively in digital format in the context of all types of criminal proceedings only in 13 member states. And in civil and commercial law, digital evidence, it is admissible in all types of proceedings only in 10 member states. So this really shows that we do have huge differences between the member states, and something that can be applicable in one member state cannot be applicable as fast in other member states. Now, however, currently we are actually in the middle of the European e-justice strategy 2019 and 2023. And the action plan that is focused mostly on the electronic administration of the judiciary, uploading data and judicial documents in electronic form, and facilitating cross-border electronic exchange of information in the framework of the e-justice project. This action plan contains several projects. Some of them also provide the anonymization and pseudonymization of court decisions for use in the field of the open data. Digitalization of decisions and their processing is prerequisite for identifying patterns in decision making and creating algorithm in the future. And of course, on the second, just recently, on the 2nd of December 2020, the Commission proposed a toolbox for the digitalization of justice, comprising 4 areas. That was the financial support to member states. Now, in this coming MFF, the Commission proposed a new program central to drive the digital transformation of Europe, the Digital Europe program, with budget 8.2 billion of euros. This fund will provide opportunities also for piloting multi-sectoral innovative technologies initiatives, in particular those ones who are based on artificial intelligence and distributed to blockchain technologies. Digitalization of justice will be funded also from cohesion policy instrument within the EU, just for instance the Recovery and Resilience Facility that we talk about much now in these days, and the Justice Program. So maybe this is enough for the beginning to start with.
Well, I think this was really a rich kind of beginning, so thank you very much for providing us with this information. Mr. Čuprik, under the level of the EU figures and strategies, including programs, there is a level of the everyday practice. What are the main issues in this innovation area seen by the Bar Association in Slovak Republic, including the infrastructure?
I am a member of the electronic or Slovak Bar Association electronic work group that that handles the electronization of the advocate of the attorneys in Slovakia, but also we are a law office that is heavily invested in legal tech and innovations in this space, and so we are able to analyze the problems that such innovation can do. So the main problem in Slovakia, especially, maybe in other states too, is the personal equipment of the judges. That even when they have opportunities to use more innovative approaches to court proceedings, they are so ingrained in their archaic ways that they despise any innovation, any new ways to do the legal process. For example, court proceedings in Slovakia can be done by electronic means. So we could have a court proceeding through Skype, through FaceTime, or other Zoom, other means. However, in my personal experience, all the judges that I proposed this kind of court proceeding, they quickly opened their books and were trying to find the exact paragraph where it is said that this is possible, and then they were trying to persuade the second party of the proceeding that they should not agree to this, because you have to agree to have a long distance or non-personal physical presence court proceeding. So the main issue above all of the issues is the personal hatred of any innovation, electronic means, and things like this. So this is the main part that we are trying to change at the Bar Association when we invite judges, or maybe work together with the Ministry of Justice to educate the judges, or trying to help them, or reach out to them and maybe just have a discussion and try to explain to them how it is better, especially as Ms. Nicholsonová, or Madam Nicholsonová said, that especially in this time it is crucial to take the innovations that are available to us and use them in practice. Of course, we need to take into consideration the problems that arise with it. For example, again, Madam Nicholsonová said that there are issues with, for example, questioning somebody that is online, but the court proceedings are immediate. So sometimes, you have to question the witness in a certain way, and you try to get them to say things that you want them to say, but if the connection is not immediate, they can maybe think about this, or maybe they can have somebody else in the room and make them do something that they would not do. So that's why we need to have maybe a little bit better rules on those kind of proceedings. The other issue of course, is the slowness of decision making, and maybe the electronization process. That is again very particular, and it's not like there is a unifying strategy regarding unified databases. For example, blockchain would be ideal to as a database means to implement some kind of unified database for judicial or decisions of the court, or evidence and things like this. And this database, blockchain database, would be accessible immediately and would be verified. So you don't have to, for example, to go to court in person, make photocopies and things like this. So you would have access to documents at the court and there will be evidence that you access those records, and you would be certain that those records were not tampered with. So there are things that we need to change, and we need to. However, we can't be overhyped about this, because a lot of the times I see in the media, on the internet, IT enthusiasts. They are always talking about smart contracts, blockchains, things like that, but they don't understand the meaning, the legal and technical meaning, and they see it as some hype, something that the technology can solve every problem. And I think that we need to go step by step and have a unified multi-year strategy and start to implement it step by step. So I see a lot of things that are going through in other states, EU states. It is good. They are considering implementing those new technologies. However, I don't see a unifying strategy that would be implemented within all of the EU states, and the interoperability should be one of the main goals of this strategy. Not only we have to just implement any new technology that comes to mind, but we need to be very smart, do step by step, and have a common goal. So in our findings at the Bar Association, we identified these problems that need to be solved first. So personal problems, like a relationship with innovation and electronic digitalization, and then to have a plan, a unified plan that everybody will be okay with and will try to implement. So I hope it's okay.
Thank you very much. Mr. Dona, how do you see the role of the technology industry? Can it somehow create maybe kind of a driving force for redesigning or maybe re-engineering the processes? And what are maybe the main technology issues as you see them?
Sure, thank you for having me. First of all, can you write?
Yeah.
Good, excellent. So, yeah, this is a very interesting question, and I just wanted to give a little bit of a background of what's happening in Italy now and what's changing as a result of the COVID-19 crisis. So we have had electronic civil proceedings for some time in place. So basically, for some time, for at least 7 years, we've been able to file claims, briefs, and defenses online. And the court would typically send a ruling directly to all involved parties through this electronic platform. And that's worked all right. Of course, until recently, until the COVID crisis, all hearings had to be carried out in presence. But things have changed, and so since the COVID-19 crisis, since May, so in March and April, we have a very serious crisis when it comes to our judicial system, because pretty much everything ground to a halt, and that was for over 2 months. And then in May, the authorities decided, and the local parts implemented some rules and procedures which allowed online hearings. I'm talking about civil proceedings here, not criminal proceedings, as I'm not a criminal law expert. But so far, I would say that these online hearings have, we've done very well. So as for technology, it's actually quite basic. So judges and courts just are required to use a laptop, which is, of course, provided by the administration, and all hearings take place using Microsoft Teams. So a very widespread, common platform. However, of course, Microsoft has enhanced security so that online hearings can take place with some ease. This is, of course, cybersecurity is a big issue. not only for our judicial system, but everything pretty much. I mean, as you may recall, Italy was one of the first countries in Europe to be very badly hit by the COVID-19 crisis. So we had to adjust before other countries to the new reality. So schooling had gone online, working has gone online. Specific work from home policies have been adopted by the government, have been agreed between unions and employers associations. And in this context, many people who used to go to the office to perform the duties have found themselves working from home. So specific cybersecurity arrangements had to be adopted. Among those, the bring your own devices policies had to be adjusted so that employees had to put in, specific cybersecurity applications so that all communications might be secure. Of course, it seems quite ideal as I'm reporting it to you. But only a couple of years ago, the civil proceedings online platform was actually hacked, which was quite a collective trauma for the legal profession in Italy, and which prompted the government to enhance security and require all the stakeholders in the civil proceedings platform to enhance security and cybersecurity tools. But coming more specifically to the subject of this conference, I think we should distinguish between two different sets of technologies. So, the online civil proceedings and civil litigation is allowed thanks to quite, pretty basic technologies such as cryptography and electronic communications. But if you want to go, a step further, you've got to analyze how you can use artificial intelligence for the purposes of civil litigation and criminal litigation. And this is more tricky. And also depends on the definition of artificial intelligence, because if you define artificial intelligence in a very broad way, so there are many tools which have been in use for some time for due diligence purposes, for pre-trial discovery or document review. You just have these programs, these algorithms, which are utilized to go through enormous amounts of documentation and can come up with quite incredible results. This is, there's been widespread for some time now. There's no big controversy around this type of weak artificial intelligence. Where there's more controversy, on the contrary, is when one tries to use strong artificial intelligence. So artificial intelligence for the purpose of decision making within the judicial system. In this case, the main issue is, of course, preventing these algorithms from being biased, for being discriminatory, but also, how can we get artificial intelligence to use some such legal tools like analogy or the ability to adapt to social customs, for example, or soft laws, for example. So this is a very open issue, and even more so when it comes to criminal proceedings and criminal justice in general. Just to give you an example, artificial intelligence has been used to try to predict whether a convicted criminal is prone to repeat his or her crimes again or not. But in order to do so, algorithms, artificial intelligence have been fed with a number of certain information, such as, for example, which is, so basically some training data which are not necessarily neutral. So, for example, race, gender, even dialect or regional accents, when they come to play, and they could actually make the whole thing, the whole algorithm, very discriminatory. Just to give you an example, I mean, as you may know, Italy is culturally and socially pretty much split in two. So we have northern Italy, which is very much European by tradition, and the south of Italy, which is more less advanced from both an economic and a financial and also social standpoint. And in the south is where crime is more widespread. So if an algorithm is, in order to determine whether somebody is more, might or might not, he's likely to commit a crime again is high or not. If you fit the algorithm, for example, the dialect or the accent, you might well end up with a discrimination between the north and south. People living in the south are more, less favored. So, and same thing. So this so much for predictive justice. When it comes to predictive policing, it's pretty much the same. So we have these programs that allow the police to predict where a crime is going to be committed. But if we feed the system with prior data, it's like a self-fulfilling prophecy or vicious circle, because the crime will be based basically mainly in the south. Police will monitor the south, and probably they will be spotting minor crimes in the area, feed the algorithm with additional data in that sense, and so on and on. And then finally, I'll just speak briefly about what blockchain technology or distributed ledger technology, DLT, can do for our judicial system. I'll be very brief here. The previous speaker has already mentioned that there's been a lot of hype about what blockchain can or cannot do. Connecting blockchain and the subject of COVID-19, for example, it is to be seen whether blockchain-based smart contracts can adjust to a number of external, changing circumstances like COVID-19. So, for example, in Italy, as a result of the COVID-19 crisis, the Supreme Court has stated that there is a duty, there's an obligation on the parties to renegotiate ongoing commercial agreements. But how would you include such a new notion in a smart contract, which is typically very, very rigid in its execution? So an option would be to have an external oracle, so depend on an external arbitrator, really. But then again, that would probably undo most of the achievements that an automatic DLT-based smart contract might add. Sorry, it was just a big, quite broad background about Italy, but I'm open to any questions. Thank you very much.
Thank you very much for really broadly brief information. Following this technology matching situation, we come to the public. Now we see there is a strong second wave in digitalization of the society, and Mr. Andrejković is one of the men who is leading this process, including the managing experts at the ministries. So maybe how is the law included in these processes?
Okay, as already said, I'm the main or chief data curator, and with my colleagues in data office from the ministry, we take care about the data. So my expertise or main focus is on data from different point of view. For example, already mentioned big data or open data. But at the beginning, we think that all the processes should rely on good quality and accessible data. So this is what we do. We already have lot of strategies and regulations already in place on international or national level. For example, once only principle, GDPR, well known, or free flow of non-personal data. European Commission recently published a draft or proposal on a Data Governance Act. We are talking about health data management strategy. So there is a lot of regulation already on international level. On a national level, we have, for example, e-Government Act. We have national concept of informatization of public administration. We have a lot of government resolutions and commitments regarding data. So there are a lot of regulation already in place, but we need to understand that the regulation is usually behind because IT sector especially is growing or developing extremely fast. So all the regulation we have usually only react on already things happen in practice. But on the other hand, we on the public administration, we can do only what we are committed to do based on law. So there are some rules already in, for example, e-Government Act. What should we do, and how are the rules? How should the rules be implied in digitalization processes? This is a little contrary because on the one hand, IT programmers and IT analytics, they need to have strict rules how to program IT systems, how to manage processes. On the other hand, the lawyers and judges, they need to have some open hands to judges according to their opinion, according to their understanding of the situation. So this is a little bit contrary between the exact rules and the open rules for the decisions. What we prepared a proposal. It's called Data Act. Is national, is different than from European Commission, and on that part we try not to hurt. It means that we would like to open the digitalization process on a public administration level, and on the other hand, not to be very strict. So the development and innovations which occur day after day could be not stopped or very strict. To have very strict rules. So law usually solves yesterday's problems, and I'm not a big fan of strong regulation. Just we would like to prepare the playground, the environment for the others to do what they want, and then we can react in our regulation.
Mm-hmm. Thank you very much. Now I make a short interruption. As far as I know, Madam Ďuriš Nicholsonová needs to leave us earlier a little. So now I give you a very brief question about the topic of security, which was already mentioned. How much the European Commission is now following this issue in its legislation concerning the innovation or applying the technology in law or all these areas, including the data policy, which was just mentioned?
Yes, Commission is very much following these issues as well as European Parliament. In European Parliament, we even have a special committee that was based this year for artificial intelligence in many areas, because this is really something that is rapidly developing and penetrating many areas of the life, including the judicial system. And I have to say that there are very strong incentives for using artificial intelligence in the judicial system. So I'm a big fan of this. Of course, there are big challenges related to the protection of GDPR As you probably know, there is this Article 22 of the GDPR, and that prohibits decision-making based solely on automated processing of personal data. It basically says that there has to be a sufficient human control to prevent the risk of rubber stamping. I have to say there is quite a disagreement about the exact scope of Article 2020 of the GDPR and on its very nature, whether it imposes a general ban on certain types of automated decisions, or whether it provides data subjects with some rights when certain types of automated decisions are taken. Of course, the legal implications of R2020 of the GDPR are causing some controversies, and this is particularly interesting when talking about the artificial intelligence being included in the judicial system. But on behalf of me, and I will conclude with this, I have to say that my suggestion would be to use the artificial intelligence also in administrative proceedings, for instance, in construction proceedings, because we might eliminate corruption, for instance. I would also suggest to use it in offenses, traffic and other offenses, because in that case with artificial intelligence that would be prepared well for such cases, would mean that everyone basically would receive the same section for the same offense. And then the third category that I would strongly advise to use the artificial intelligence, maybe especially in Slovakia, would be the legal proceedings, debts to financial institutions, such an issuance of payment orders, criminal proceedings, selected criminal offenses, theft, non-payment of maintenance, selected acts in execution proceedings, etc. Because I really am in touch with a lot of citizens, and basically even people with the same identical cases, they receive different results from offices. And just for example, we have employment office in Stropkov and employment office in Žilina, and where two disabled people with the same diagnosis, with the same degree of disability, similar family or financial conditions, receive different decisions. And this sometimes happen even in one office. So I would really strongly advise that we start using artificial intelligence to prevent this different kinds of measures when it comes to the people and to cases when talking about the judicial systems when it comes to cases of the same legal substance.
Mm-hmm. Thank you very much, and Madam Ďuriš Nicholsonová, thank you very much for joining us at the panel. Thanks.
Thank you to all of you.
Now I will follow to Mr. Artim. We see digitization as the topic mainly associated with various applications, big data and other digital tools, but what is the role of the hardware and what you see as the main issues in this area?
Hardware technologies, I think, significantly contribute to the shift in innovation, digitization, and technological processes as well. Here are some examples. For instance, our company, Alcom, develops and produces fiscal devices with all security details that eliminate tax frauds. As well, we develop and produce specialized industrial computers, which, for instance, in the biggest mine in Poland, did reduce data processing time from 1 week to online processing. In technical language, it was from paper to fully electronic way. In managerial language, from statistical management to managerial management. Also, actually, is very interesting time where computers are integrated in special breathing units of company Hirana Medical, And these breathing units are world-class solutions in artificial ventilation in fight against coronavirus. These are some examples from the other areas where hardware technologies help and support innovations. In a sector which is much closer to judiciary, we create environments so that data are in electronic form from their creating. Thus, we have developed innovation solution that allows applying of full electronic processes. That is, documents that are objectively created in banks, mobile operators, healthcare, government sector, and which must be confirmed and signed by client, citizen, or employees of the bank, for instance. They do not have to be in paper form. So the documents are in electronic form since their creation. It is many times now it means to create, print, sign, scan, save, archive documents, and also transfer of documents to some central archives. So summary, I'm sure that the hardware technologies are more than important base for innovations.
So now the question to Mr. Kryška. We see the development is really fast, and we saw some areas, but what may be the new areas for applying technology in law, also in your business, maybe for the new coming or startup companies which are aiming for the international success, not to take the legal procedures as an obstacle, but maybe as something we just have to be passed.
Good afternoon, everyone, and thank you for having me. Yes, we in Sparring, we are in a kind of unique position of sitting between the regulation attorneys and innovation, in that we are being, most of us, attorneys ourselves, but at the same time we are developing our own legal tech solutions, and we work on building products with disruptive tech companies who are our exclusive clients. So in that regard, legal tech is a core essence of us. And to join it to the topic of this discussion of the rule of law, I'd like to add that for the rule of law, access to justice, it's one of its main pillars. And in that area, legal tech has much to offer in terms of all the simplification of the processes, automatization of processes, or digitalization, as we mentioned several times already across the panel. But to keep things as they are, the innovation in legal industry in CE, and especially also in Slovakia, is not easy because we are a very small market. Law is different in almost every country to big extent, and legal tech startups, when they're facing decisions in which countries to implement or prepare their solutions for, they would rather go to Germany or UK or bigger markets than to us, to Slovakia. So, and this, when it is combined with a regulation, which is still quite heavy in the area, can create obstacles, and it's slowing down the legal tech industry that we currently have it. So I would say that the tech is ready and it's moving fast, but we need to keep up with adjusting the regulation and allowing for the change to happen. For example, when it comes to data, for example, we need more open data sources to train our AI models, because when we want to automate processes, we need that. And currently, for example, with the Slovak Office of Intellectual Property, we do not have access to the open data. And so we cannot automate, for example, creation of the trademarks on which we are working on. And on the European level, with the European Office, it's much easier because we are further in that area. But yes, as a legal tech, there is a huge place for productivization of legal services. And as an attorney myself, I would like to comment on what it practically means for us as well. So we believe that thanks to the technology, the future of the attorneys can be very bright, because the legal tech can get rid for us of most of the mundane or repetitive legal tasks which we are currently facing and which are time consuming and also costly for our clients. One example for example, in M&A transactions, from my experience, 60 to 80% of the M&A transaction time of attorneys is spent on the due diligence, where a team of lawyers is reviewing one by one hundreds, if not thousands of documents, and this can be automated. And there are several startups who are trying to do that. We need to start with easier documents. For example, the startup Clarity is working on automated review on NDAs, non-disclosure agreements, and the software automatically flags the non-standard clauses, and therefore the human touch or the attorney's time is already pre-filtered before the attorney comes in. But at the same time, there is also a huge place for public improvement in this area. When we compare it to other jurisdictions, myself being qualified in New York, for example, setup of companies, when comparing to UK or US and Slovakia, it's much easier. And in UK, for example, it's as easy as 30 minutes of time of a layperson not needing an attorney to set up an LTD or a simple company by shares and start doing business. This is not possible. Another big topic here is small claims adjudication and enforcement. Again, UK can be a good example of a working small claims court, and we should strive to be building solutions for citizens to be able to self-help more. Because when we are talking about technology, we should be creating user-friendly technologies where the person does not need help of attorney to go through a complicated process or legal jargon to enforce its rights. And with the small claims, for example, it is super easy. And in the UK, when it comes to the simple claims, as for example in employment, to when there has been a wrongful action by an employer, to simply state a claim as a layperson and put the employment contract online and wait for a quick decision. Also, this is not done by judges, but the courts of the clerks of the court, which is simpler, and it makes the claims to move much faster and to get results within matter of weeks. So I would say that in this process of digital infrastructure, there are plenty of opportunities which we are currently not exploring. And yes, it is more difficult for us in a smaller market, a smaller country, but we have the tools, both from the European Union and from within our own legislative process, to speed up and accelerate what we can do within the next years.
Mm-hmm. Thank you very much. So there were a few more examples of the practice, or maybe the solutions mentioned in between. So maybe from your practical point of view, what are the areas where the technology may really improve not only the benefits of the attorneys at law work for the people or companies, your clients, but also for your work?
I think that I will start by saying that from the general point of view, it's in my opinion the place of the technology to help with the tedious tasks, with the everyday tasks, with the small tasks of people, like administering some registries such as companies register or other similar type of registries. And this is where I see the easiest path to digitalization and to helping also attorneys and the general public to get a better user experience from the digital technologies employed by the state. But I think that discussion itself must be made broader, or must be broader than only where can the technology help. I think that we need to state what the solutions should achieve, and I think personally that it should be interoperability between systems. Like now, you have Slovensko.sk for a few types of things. Then you have a separate register, or a separate portal to communicate with tax authorities and so on. So this is something I would like to see go away and to be united under under one platform. I also think that the digitization is also thought about in very old terms. I think that we need to acknowledge the role of mobile technology over standard technology like PCs, like tablets, because mobile phones are the lifeline for the modern society, and also it is almost so that everyone has a smartphone which is able to help him with this basic task without going to a clerk, without going anywhere, from the comfort of one's home. So I think that when finding solutions to this digital task or digitization, we need to focus more on ready-made solutions, or utilize more ready-made solutions, and only revert to bespoke solutions when no other solution is possible or viable. Also, I think that automation can help on the part of the state with some administrative tasks that can be safely and with high efficiency made by the technology, with only small input from the actual human being, or with only a final control from a human operator to check whether the system made a good decision, or made the process as expected. So I think that when we focus on lowering the barriers of entry into using the digitized services, we will make a great deal for propagating the rule of law, and also to make these tasks more convenient for the general public, and to be up to date with using the technologies.
Thank you very much. Mr. Andrejkovič, we've been discussing the strategy, decision-making level, the practical problems, or maybe some kind of a visionary technologies for the future. How much does it match, or maybe find the schedule of the digitization in the public for Slovakia?
Okay. Well, we are in process of preparing new national concept of informatization of public administration. We are preparing a completely new data act. So there is a lot of regulation already in preparation. But on the other hand, it's not the regulation is important. The acceptation of this regulation is very important. As we already heard, for example, judges, they are actively advocating against using of some innovations, or they are refusing to use it. On the other hand, the IT people, they are asking for strict rules and strict processes. We all ask for stability in the legal environment and regulations. But on the other hand, we as well are calling for fast adapting new innovations. So sometimes it looks like this is very in contrary. The answer is not to prepare the regulation in-house, but to open it to public, workshop, seminars like this Legal Summit. And participation of all stakeholders involved is really the key to not only to prepare and adopt the rule, but then to follow it and to work within the regulation. I'm very curious in Malta's example. In Malta, this is a small country, they already have AI strategy in place, and they started 3 years pilot experiment to have AI in public administration running next to official public administration decisions. So after 3 years, they will compare whether the public people's administration decisions are same or different than the AI decisions in the same field. So this is what we should do now, not only to prepare the regulation, but to find a way how to prepare so-called regulation sandboxes or some hubs in order to at the beginning to have a pilot in some solution, in some regulation, and after it fits, after it's good adopted, then to spread it to all public. So this is what we would like to do, not only to have a strict regulation, but to prepare some pilot or sandboxes.
Now I question to any of you who is interested, do you think it would make sense to create kind of an open platform to discuss such issues concerning not only the technology implementation, but also, let's call it, qualification issues for all the people in the system, judiciary system, or something like this, maybe in this form, but also in some more focused form? But what do you see? Can this work? Maybe kind of a legal tech cluster or something like this? Yeah? Take the microphone, please.
I think that there are discussions in place already. So, for example, the government always seeks the advice of, for example, attorneys or technology firms. They have like open discussion panels, open, quote unquote, open. Only certain invited individual subjects are participating. However, these discussions are just that, discussions. The main part is the political will to enforce and implement such things, and I'm very sad to say that the politics are always the deciding factor. So, for example, we have technology in place, and we have a simple way to implement a regulation that would take these technological advancements into consideration. However, there is no political will. Okay, there is always a discrepancy between the needs of the populace, the state, the population, and the needs of a political party that is the leading party. So discussions are in place already, but they are not the deciding factor on implementation. So I would suggest these discussions are perfect. I would very like to see that these discussions are maybe more transparent and more people from the government would take place in such discussions, and a public forum. We already have a public forum. We have the internet, but they need to be more involved in such discussions, and the results of such discussions should be taken into consideration when making legislation and technological advancements. But as the situation stands right now, it's just a discussion, and we are at the hands of the politicians if we want to have something good implemented. Okay, so.
Maybe the way how we can unify the decision making at the political or public level to the practical needs is the kind of education like make it as a training workshops for the experts from all the levels, from all the sectors, and maybe this may work because all the issues can be discussed, but at the same time, the solutions can be made at this part. Mr. Dona,
I think
you told us about some new technologies and maybe to ask about other new technologies implied. Can you just brief us? Can you inform us like how these can be implemented in the practice? What form was used in Italy to really use it and to solve problems like we are facing here in Slovakia? But just briefly.
Of course. As I mentioned earlier, I think artificial intelligence is really the most challenging technology when it comes to application to the judicial system or to the administrative system. So just to give you an example, a couple of years ago, there was a big program was put in place in Italy to use an artificial intelligence algorithm to assign school teachers to schooling districts. And it may seem quite an easy task, but it was not, because lots of people, lots of teachers were not happy with being assigned to schools very far from the residents. So they appealed the decision, and the grounds for appealing was basically that the motivation of the algorithm behind the decision of the algorithm weren't clear, weren't transparent. So the public administration countered by saying, look, we can't open up the algorithm for you because it is protected by intellectual property. It is, the AI supplier, vendor, has rights, IP rights over the algorithm. And so eventually, the teachers' union sued the government, and an administrative court decided. And then that was the first instance. And then there was an appeal, and there was eventually the Supreme Administrative Court decided over the question. And the decision was that between the teacher's right and the right, intellectual property rights on the algorithm, the former prevailed. So basically, it was ordered that the black box, the algorithm, was opened, and the source code could be examined by the unions. But of course, this is a very interesting but also very dangerous precedent, because now many AI vendors, suppliers in Italy will fear having to open up the industrial secrets, the intellectual property, to the parties. So this is, the main issue at the moment is AI, artificial intelligence, as a black box, as something that you can't open, and if you do open it, you will be exposed to the risk of harming intellectual property rights of the algorithm vendor.
I think Mr. Crandall was asking for a word.
I just wanted to supplement what the Mr. Ďuriš said. In that I think that right now the position is correct that you described, but I also do think that we need to have these discussions and to narrow more the divide between the public, or between interests of the public and interests of the political parties that govern us. And I think that such forums may, with other activities, may contribute to better political will in the future. So I think that it is really important to establish a forum where political parties can be brought up to speed by professionals, by members of the general public, of what is possible and what is wanted, or what should be done in the best case. Thanks.
And Mr. Artem, I also ask you for a brief reaction. We'll talk about the issues in the legislation, in the systems, in the data management, but what about your area, the hardware? Do you think the devices can be used to make it all work and or make it more efficient?
Yes, let me explain you briefly, in principle, our solutions and why we think that it's solutions and it's confirmed by our customers. For the digitization, we offer multifunctional signature devices, which allow to view document, to view in document, and to zoom in document if necessary. You know, I can't zoom the paper. That's why it's much better, more comfortable to do it on some signpad or some display. And if necessary, I can edit document. And finally, this is important, I can sign this document with a handwritten biometric signature directly at the place which is designated for signature. I can even sign the document with electronic signature if necessary. It's as well important. It means I can sign document with handwritten biometric signature and electronic signature as well. Of course, after signing, I see my signature in document, and this significantly increases the confidence of the whole process. Finally, the document is logged with a security certificate because security is on the first place in such sensitive documents and can be immediately available for further processing. Significant added value of the solutions is ability to identify the client or citizen or employee via EID or payment card or contactless card or even using the fingerprint or QR code. Thanks to this, in document, link citizen, document, and signatory is secured. In addition, it's possible to have a special module in this device which can scan document brought by citizen to institution and can even hear and record conversation with the citizens. So what are the benefits of such solutions and the potential reason for using in judiciary? Much higher data security, it's first, because mentioned biometric signature is not possible to fake. It has a visual part of signature, of course, also pressure, speed, and acceleration, which means that the document signed in this way is much more secure than on paper. At the same time, it keeps as well, it is important information, exact date and time of signing in case of forensic needs. It's easy to check it. Related to this, there is possibility to object in a faster verification of signature by software, not by graphologists.
So one last thing, Mr. Kriška, we see any innovation is implemented as people adopt it and really utilize it. You can compare the situation in various markets in the world. How do you see what are the working ways to really make people use the innovations and really make it work in various situations? But what can help the Slovak market? And then how can it change the legal services, in your point?
Yes, so just very quickly, being conscious of the time.
Yes.
I think that for citizens, it's easy. It needs to be made simple, easily understandable, and user-friendly. When you provide them with such a service, they're much quicker to adapt it than when you place an administrative obstacles in their way. When it comes, for example, to the digital courtrooms, yes, there always be a resentment from the older judges, for example, and it was in my home state in New York as well. But they didn't have a choice. Like the regulator decided that they will be hearing arguments online, and they had IT infrastructure and help, and also clerks to help them adapt it. But they did in the end. And so I think that the technology adoption can be painful for more conservative generations, but at the end of the day, it's inevitable. And in certain ways, and we need to carefully choose where we have to push it through.
Mm-hmm. So thank you very much. And let me now just thank in the previous part, Madame Ďuriš Nicholsonová and all you gentlemen for opening this, probably not closing, but opening these important questions. And I think one of the most important conclusions is that the communication in whatever form, not only as an education, but also discussing the problems and issues, can really be the way to solve and to accelerate the innovations, and that can really help all the customers and the people in the practice. So I think the one of the question put, if this can be part of the maybe more regular platforms discussions, I think this is kind of an issue, and I hope we will meet each other again. So thank you very much for seeing us at this part of the Legal Summit and the panel, and you can also hear this and the rest of the agenda on the internet. So thank you very much and have a great day. Bye.
Thank you very much.
Thank you. Bye.